This lecture is on Module 11, Religious Freedoms. I'm going to start out just discussing for a little bit the historical setting of the Constitution and then of the First Amendment. When we're talking about religion, there's the joke that you should never discuss religion or politics in like at dinner, right? Because those are the two most controversial subjects, and you don't want to wind up in a fight with your family members. And that rule applied from the very beginning of our country. Religion has always been a controversial topic. Um, it, it's only addressed in their original Constitution in Article 4 with the provision for no religious tests. This is the text of Article 4. It is preceded by a discussion of the oath of office that senators and congressmen have to say. But at the very end, it says, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So what's interesting about that is that it's a reflection of perhaps the fear that the framers had about trying to provide some sort of rules or protections for religion, because they knew it would be nearly impossible to get all 50 plus men to agree on something so controversial as religion. Um, but they did agree about this no religious test requirement. And it's probably because they'd seen the awful consequences of it in their history. These are settlers from England. And in England, there is a national church, or was a national church, the Church of England. And for hundreds of years, Catholics were persecuted, and also other religions that were dissenting from the Church of England were persecuted in England. And that's one of the reasons some groups left England and moved to the New World. So with that knowledge about the way England had required religious oaths before someone could serve in parliament or any other public office, you had to swear an oath to profess the beliefs and the practices of the Church of England. Otherwise, you couldn't have a job. So it was a way of keeping Catholics and religious dissenters away from having any sort of political power. It was used to discriminate. It was used to oppress. And the founders of our country were in agreement that that would not be true for the United States of America. However, in the colonies, religious oaths were required. They were common. They were part of the charters that the King of England gave to settlers to found their colony. It was part of the rules of the colony's formation, and the rules stayed even after they were no longer colonies and became states. They continued to have, at the state level, requirements that people seeking public office would have to give religious oaths. But as far as the national government was concerned, that was not going to happen. There's really not any evidence of the debate over that article or that part of the article in the Constitutional Convention. So we don't really know what they were thinking or the extent of the controversy, but we do know that the framers agreed to have it, and that part was not particularly challenged. But during the ratification process, the subject of religion came up, or really for the need to have even greater protection for religious freedom. That was something that the anti-federalists and those who were opposed to ratification were serious about and wanted to see become part of a Bill of Rights. So that's why it came to be part of the First Amendment. And that language that we have in the First Amendment, the anti-establishment clause, the freedom of practice, religious practices, that was kind of kick-started by the colony and then state of Virginia. The author of the Constitution, James Madison, came from Virginia. He worked with Thomas Jefferson, the author of the Declaration of Independence. They were both from Virginia, and they were both opposed to government support for an established religion in Virginia. And so in their states, they had been advocates for a bill called the Bill for Religious Liberty. And that was primarily targeting some laws that had required people to have to pay taxes, and the taxes would then be used to support the church, the Anglican and then the Episcopal Church in the state of Virginia. So people's tax monies were paying the salaries of the priests and the church staff, and they were supporting the church building. And so it was, at one point, the law of Virginia would require people to pay taxes, and those taxes were used to directly support an established church. And here is Thomas Jefferson, James Madison, the writers, the founders of our Constitution and our national government, opposing that type of regulation and authoring a bill to eliminate it, a bill for religious liberty. That bill became the foundation of our First Amendment. The language from it came from that bill. Keep in mind that the time at which our Constitution was being ratified was a time of much religious pluralism in the colonies. There were many colonies that upheld religious freedom, and they were devoted to religious freedom, founded on religious freedom, and allowed a great deal of pluralism. There were other colonies that had established churches, but there were a variety of different churches. There was no way to really identify any single religion that all Americans would or should adopt or believe in. So there was really no feasible way to have an established religion in the United States of America, no feasible way to do it. And our founders believed also that religion should be a matter of choice, a matter of conscience, and not a matter of coercion. So they brought that in along with the Virginia's Bill for Religious Liberty. They brought that in when they were writing the First Amendment. The First Amendment, keep in mind, it only applied to the national government at its start. We weren't, although Virginia was kind of taking the lead on eliminating state endorsed churches, other states were going to maintain state tax supported churches in their states for a few more decades after it. So the First Amendment is there to limit the power of the national government to prevent a nationally established church. And so we get two clauses in the First Amendment. We get an anti-establishment clause forbidding the promotion of religion, and a free exercise clause forbidding the suppression of religion. They each are kind of analyzed a little bit differently. There is very little consistency in the way the court has interpreted those two provisions over history. But as we go through and look at the cases, this module is very heavy on the cases and looking at what the law was and what its impact was and how the court reasoned out the interpretation. As you go through them, you may or may not see a pattern, but you will learn a sort of a progressive change from one framework of analysis to another that kind of leads us up to modern time. The two clauses often conflict with one another in an effort not to allow state support for a church. States have wound up interfering with the exercise of religion. So they kind of have to balance out their role in not promoting religion, but also not suppressing it at the same time. That's sometimes a difficult balance. We'll see that as we go through the cases. But before we do that, we've got to conquer the definition of religion. And there is no definition of religion. There's no single definition of it. We have a case that gives us an analytical framework. A religion is going to be determined by the sincerity of the individual's belief. the extent to which it provides a collective moral code, not just one individual asserting something, but the individual belongs to a group who adhere to a collective moral code. And the code centers around a supreme being or some philosophical equivalent of a supreme being. Doesn't have to be a god, doesn't have to be theistic at all. So there you go. There is no definition of religion. It is a case-by-case determination made using that analytical framework. All right, so with that in mind, we're going to talk about the Establishment Clause. As we go through the cases, you're going to see a progression through 3 different theories for interpreting the Establishment Clause. The first is strict separation. This is a theory that there should be absolutely no commingling of government and religion at all. That there is an absolute impenetrable wall of separation between church and state. That works once or twice, but as you look at the cases and you look at real life and the way government deals with religion, the way it treats religion, strict separation has never been accomplished. There are many adherents to that theory, but they don't comprise a majority. So we've not ever in the history of our country been able to uphold any sort of wall between church and state. The other theory is neutrality, that government must remain neutral towards religion, that it cannot promote any particular religion and it cannot promote religion over secular religion. That is probably one of the most commonly held theories, the one you'll see most often applied in the cases. But then now we are seeing more and more the theory of accommodation, that government may accommodate the presence of religion, even in some government activities. Government cannot coerce it, but can accommodate it. And an example of that is this quote I've got on the slide here for you. This is what the marshal for the U.S. Supreme Court says every time the U.S. Supreme Court is called into session to hear an argument. The very last line, God save the United States in this honorable court. So there you go. Our own U.S. Supreme Court, charged with defending religious freedoms, their presence invokes the existence of a God. So there's an accommodation of religion right there. It's just a tradition, and it's just been upheld since the beginning of our country. So you really can't get around that. You really can't get around some sort of accommodation between church and state, for better or for worse. It's there. All right, we're going to start out looking at cases that involve government aid to religious institutions. And if you remember, I was talking about in Virginia how James Madison and Thomas Jefferson, they were targeting laws in Virginia that provided for direct government aid to an established church in Virginia. They were targeting that as being inappropriate and illegal and contrary to good government. So take that and fast forward a bit, and we get the very first case to ever consider the meaning of the Establishment Clause, Bradfield versus Roberts in 1899. It involved a grant to a Catholic hospital to build a ward for the treatment of poor people. And so there you go, direct government aid being handed over to a Catholic institution. The U.S. Supreme Court upheld that aid because it was being used for a secular purpose, to provide medical care to indigent individuals. And so that is the case where the court identifies the necessity of a law having a secular purpose, where a government law has a secular purpose, even if it incidentally benefits a religious institution. If the purpose is secular, it's okay. The next case is Everson versus the Board of Education. I've forgotten what state, 1947. And it kind of builds on the Bradfield case. It involved a law that provided financial assistance to parents. So it wasn't given directly to the schools. It was a reimbursement or money given to parents to pay for busing, essentially, to take their kids to school. And some of those schools the kids were taken to were parochial. Parochial means religious institutions, religious schools. And again, the U.S. Supreme Court upheld the law, and there was a reasoning for it, and it was the fact that that the law was generally applied. All parents received this assistance, regardless of where they sent their kids. So that means it wasn't only given to students going to parochial schools. It was applied generally. That is a picture there that just came up of the hospital from the Bradfield decision. But we're dealing with let me go. There we go. There's our buses. And that's what the Everson case was about, was taking kids to school. So the law applied generally. All parents within the city received the funds. The funds were provided to parents for the benefit of their children, not directly to the schools. It was not direct financial aid. And again, here we have the secular purpose. The law had a secular purpose to provide safe transportation to schools in a community where there were no schools available. So it had a good purpose. The majority of that case talked a bit about the intertwinement of the Establishment Clause and the Free Exercise Clause. If the state had denied financial aid to parents sending their kids to the parochial schools, there was an argument that it would be a discriminatory law and infringement of free exercise. So the majority talked about it, but didn't get into it too deeply. We start to see that a little bit later. Following the Everson decision, state legislatures were the case kind of cleared the way to develop other types of programs that were to help schools, to help parents, and to help children have access to good education. And so new laws were being written, and they involved incidental support for religious schools when parents chose to send their kids to religious schools. And then another line of cases involved tax exemptions. A tax exemption means that certain business organizations are not required to pay property taxes to the government. This is a common practice, and it isn't just about churches. It isn't just about religious institutions. Any nonprofit institution, if they qualify for that tax provision 501c3, if they qualify for that exemption based on the application of that tax code, they're exempt from paying taxes. And sometimes churches do qualify, and sometimes private schools, parochial schools qualify for that tax exemption, but they're upheld because those tax exemptions are universally applied to all nonprofits. It's not just religious organizations receiving them. So even if you're coming from the strict separation theory, you see that as financial aid from the government going to a religious institution. But the majority of the Supreme Court has not gone that direction. They are upholding tax exemptions because they apply generally to all nonprofits, not just religious ones. All right, the next case that we're going to look at, we're going to go back now to schools. In the decision of Lemon versus Kurtzman, this was a case that involved a program where the state was going to reimburse school expenses, expenses incurred for textbooks, for teacher salaries, and other materials. The state was going to attempt to perform really detailed audits of this reimbursement program to try to ensure that the government aid was only devoted to secular aspects of the education. But they're still going to be received by schools that were parochial. And so that was creating a potential violation of the Establishment Clause. And in Lemon versus Kurtzman, the court struck down the law, but it was because of that requirement for this really detailed audit. It involved too much entanglement between government and religion. So that word entanglement now has entered into the analysis of whether there's an Establishment Clause violation. And we get this sort of new rule that, so we had the one from Bradfield and the Everson case. Now we've got the Lemon test. So they keep the secular purpose element. Does the law have a secular legislative purpose? Well, in Lemon versus Kurtzman, yes, it did. It was to promote the quality of education. Does the primary effect of the law neither advance nor inhibit religion? Of course, yes. This was an ability to reimburse expenses for schools generally. Now, parochial schools were receiving the reimbursements as well, but it wasn't, they weren't trying to advance any particular religion or inhibit it. However, the third element, does the law require excessive government entanglement? And that's where this case turned. There was this extensive audit to try to manage the government aid and keep it only going towards the secular aspects of education. That was just too much government entanglement there. And so the law was struck down. So now we have this new decision, Lemon versus Kurtzman, that is an effort to apply a consistent framework for the U.S. Supreme Court on all religious freedom cases. But that never happened. The Lemon test has never been consistently applied. At times it has been outright ignored. So as we go through, I'll mention where it happens, where Lemon gets ignored. And you'll see how it just was never really consistently applied. After the Lemon test, after that case, the U.S. Supreme Court kind of continued to be very reluctant about upholding these financial aid programs. But in the 1980s, that kind of shift. That was when Justice Rehnquist was confirmed to be on the U.S. Supreme Court and kind of pulled in a new majority that was far more lenient towards these financial aid programs. And so from the 1980s going forward, we'll start seeing U.S. Supreme Court holdings that fall in favor of allowing government aid, even where it may wind up in the hands of a parochial school. The most modern application of government aid and it winding up in parochial schools has to do with private school vouchers. Now the vouchers, they have a secular purpose, and that purpose is to provide school choice, to give people of all economic backgrounds the ability to send their children to any school, to the best schools in the community, even schools they couldn't otherwise afford. So there's a valid secular purpose there. Better education for students, great. And so the problem comes where the best schools in a community are also church-run schools. And so even though the money is being given to parents who choose where to send their kids to school, there may be no other school to use it at other than a church-run school. So that's why we get a problem. The Zellman case is one that is in your textbook. And that was from 2002. And again, we've got the more conservative court. And it held that the tuition aid program was constitutional even though 96% of the students receiving the vouchers were applying it to a Catholic school. The tuition aid, though, was part of a comprehensive school choice program. It included funding for students who chose to attend public schools, all 4% of them. And so it didn't advance religion, it didn't limit it in any way, had a secular purpose. And the fact that the aid is being given to parents and not directly to the school, that's what the court turned its decision on. The parents' choice was the reason the funds went to parochial school. The government didn't make that choice for them and therefore was not promoting religion. As long as it's not promoting it, it hasn't violated the Establishment Clause. That was the ruling. Your textbook does not have this case, the Carson versus Mackin case. That's a very recent one. And it involved the state of Maine, where a similar program where vouchers were being given to parents to cover the costs of sending their children to various schools. However, in Maine, they were being careful not to promote religion. So they told parents that they could not use it. If they were going to send their kids to a parochial school, they could not receive the vouchers. And so a parent who'd been denied a voucher because they chose to send their kids to a private school, a parochial school. They claimed a violation of not the Establishment Clause, but the Free Exercise Clause. They said this was an infringement on their religious freedom. That the law was being applied discriminatorily against religious beliefs or religious practices. And in this case, this very recent case, the court sided with the parents and said Maine had to give the vouchers to any parent. They couldn't discriminate on which parents received the government aid, even if the parents were going to wind up giving the voucher money to a parochial school. That would not offend the Establishment Clause. So it would be discriminatory and an infringement of free exercise to deny them to parents sending their kids to a private school. And that's one of the best examples we've got, the Carson case, of that sort of conflict between the Establishment Clause and the Free Exercise Clause. Maine had a good intent. They were trying not to violate the Establishment Clause, but they wound up violating their Free Exercise Clause. The financial aid to higher education actually there are several cases, Supreme Court cases, looking at financial aid to colleges and universities, religious colleges and universities. But we're not going to get into that in this case, in this class. Just know that the concerns are a little bit different when we're dealing with college students. There's less of a concern about the government being seen as promoting religion when government aid is used for private universities, church-run universities. There's less of a concern. So we talk a bit now about school prayer. Historically, many public schools included religious practices in their daily schedule. Even Bible studies, that was commonplace historically. And that just has to do with the way public education sort of developed, the history of public education. And I don't have time to go into that, but it's an interesting history. Churches are responsible for the development of a public education system. Just know that. And as a consequence of it starting out with churches, many public schools involved religious education. And as time moved on, it included Bible studies and prayer in schools. And so adherents to the strict separation theory believed that these practices violated the First Amendment, and they brought their arguments to the U.S. Supreme Court in the case of Engel versus Vitale and the Shemp case. Those were the two school prayer cases in your textbook. In those cases, the court held that prayer in school would be was a violation of the Establishment Clause. In the Engel case, there the school actually wrote the prayer, and then the teacher led students in reciting the prayer, and that was the problem. That was the promotion of religion by a state employee. So that was about obvious violation of the Establishment Clause. In the Ship case, this is where the school, they didn't write the prayer. It was the Lord's Prayer. It came from the Bible. But they were leading students in a Bible study and in the recitation of that prayer. And so because these were state public school teachers leading students in a religious exercise, that would be a violation of the Establishment Clause. Now, in both of these cases, the students' participation in the religious exercise was voluntary. So a student could choose not to say the prayer. They could choose not to bow their heads and fold their hands. I think in the Ship case, they were allowed to leave the room. But ask yourself, put yourself in the position of a child in that setting. Would you want to be the kid who walked out? Like the only kid who didn't bow his head or her head and pray with the other students? I mean, this is a time where conformity matters and kids are insecure. They don't want to be different. And so the court talks about that. They acknowledge the fact, yeah, participation is voluntary, but it's still coercive because we know how children are afraid to go against the grain, to stand out and be different. They just want to be like other kids and do what other kids are doing. And so it's, even though it was voluntary, it still had this coercive effect. And that's why the US Supreme Court said, just because it's voluntary doesn't mean it escapes the Establishment Clause. There are similar holdings that followed Engel and the Ship case involving moments of meditation and voluntary prayer held at the beginning of the school day, student-led prayer before a crowd at a loudspeaker, like before graduation ceremonies or football games, where schools inviting clergy from the community to come in and lead prayers. And in those cases, at least until very recently, the schools were prevented from doing that. That was considered a violation of the Establishment Clause, because these are public schools and the participation in it still was coercive to an extent. Like, for example, at a football game, the football players had to be there. Cheerleaders had to be there. Members of the band had to be there. So they really had no choice but to be present for these religious exercises. And that was a problem. The Supreme Court felt like that was coercive. But the most recent case now is the Kennedy versus Bremerton School District case. Now we've got a very different US Supreme Court. And in this case, it involved a situation where a football coach, he wasn't requiring his players to come and join him in prayer. He voluntarily just did it. He just walked out the end of the game, walks out on the 50-yard line, kneels down and says a prayer. He's a religious guy and that's what he wanted to do. But he's the coach, and the players saw him doing it and wanted to join him. And then other spectators at the football games joined him, and then members of the media joined him, and then players from the other team came and joined him, and it became this big crowd of people out on the school's football field saying a prayer. And so the school was concerned that they could be the target of a lawsuit where someone was claiming they were violating the Establishment Clause by allowing him to go and allowing these others to go and pray on the football field. I mean, he was an employee of the school and he was in a position of authority, and they thought that they would be the subject of a lawsuit on the Establishment Clause. So they told him to quit, and he wouldn't quit. And so they fired him. And so to start this case, He challenges the school's decision as a violation of his free exercise of religion. And the U.S. Supreme Court agreed with him. They abandoned the Lemon Test outright. The author of this decision, I forget which justice it was, but he said that the Lemon Test has never been consistently applied, and it will not be applied again going forward. Instead, we are going to look at the extent to which the activity of the government is coercive. And in this particular case, there was no coercion involved. The school had nothing to worry about. This was just the voluntary action of one person to go and pray. And so it would be a violation of his freedom to pray for the school to stop him from doing it. So now our new test, then no more of the Lemon Test. Our current court is just going to focus on the history and traditions of our country at accommodating religious practices. So here now we have the accommodation theory of the Establishment Clause being adhered to by a majority of the U.S. Supreme Court. That's where we're at currently. That's the theory that our U.S. Supreme Court is going. A little bit about creationism. So that is the religious belief that God created the world in 7 days that is found in Genesis in the Bible. Like I said, religious education was part of public education historically. And it became a problem as science taught us that the world actually was not created in 7 days, rather over the course of about 1 billion years. And so schools were being asked to teach that those scientific principles of evolution that conflict with creationism. And that upset parents, religious parents. And it kind of came to a head in that famous case, the name of which I'm forgetting, the Scopes Monkey Trial in Tennessee. That's not just a movie. That's an actual real case that occurred in Tennessee. And so in the end, the U.S. Supreme Court, and they actually kind of consistently held that states cannot require schools to teach creationism. Let's see, I've written down that the 2 cases that address the issue applied the Lemon Test. So this is before, these are old cases. They applied the Lemon Test and found that the purpose of the state law was not secular, but rather to promote a religious point of view, that the biblical interpretation of the beginning of the world was the correct one. So it was promoting religion, kind of blatantly promoting religion. Therefore, under the Lemon Test, it was invalidated. Schools could not require teachers to teach creationism. Don't know how that would turn out today, but at least then. All right, now we're going to look at religious symbols in the Establishment Clause. And here you really got to look at the facts, the actual monument involved. You got to see it to understand it. So I've tried to put pictures in the PowerPoint for y'all to see what we're talking about. First of all, though, we have to note symbols of Christianity can be found in many different locations around our country. You will see crosses, the 10 Commandments, nativity scenes, In God We Trust. You will see that mixed in religious buildings, on money. You know, it's everywhere. So adherents to the strict separation theory have always challenged that as a violation of the Establishment Clause. But the displays remain, and they are commonplace. And sometimes they're upheld, and sometimes they're not. And there really is no rubric or test that leads to consistent results in any of these cases. They are very fact specific. It's created an awful dilemma. The justices in the U.S. Supreme Court hate it. You can read Justice Breyer's concurring opinion in the Van Orden versus Perry decision, and you'll see him talking about how terrible this area of the law is, how inconsistent it is. But we got to live with it. And I'm just going to give you a few examples of monument cases here. Okay, so this is County of Allegheny versus ACLU. It's a blurry picture, but you see there's a staircase there in this government building, and it's real fuzzy, but there's a nativity scene there. And I think it's surrounded by poinsettias. And there was a sign above it that had some religious message on it. I don't remember exactly what it said. Anyway, it was a nativity scene that had been, it belonged to a Catholic church, but they got permission from the city to display it there inside this courthouse. But you can look at the context of it. It's right there in the main hallway, and it's huge, and it has an obviously religious message. So the court said no, that was too much promotion of religion. Here's the outside of the courtroom. There is a giant menorah, and it's right next to a Christmas tree, a very large Christmas tree. And there is a little sign. You can't read it in the picture. It says "Salute to Liberty." A Jewish organization owned the menorah. The city set it out each year, and it was next to this message of kind of professing pluralism in the way that our country celebrates religion, and celebrates this winter season. We have Christmas trees that are used by some people, menorahs used by other people. So when it was placed in this religious monument, this menorah, when it's placed in that context as being part of a pluralistic celebration of a holiday, then it's okay. So in that context, the menorah was fine, according to the Supreme Court. Here's our next case. I've got a better picture. Van Orden versus Perry involved the Ten Commandments monument. I think it was in Texas. Texas Capitol building. You can't tell in the picture, but there are several other monuments on the grounds of the Texas Capitol building. And they all are kind of talking about, or they're all monuments to various things that impacted the development of the law and the development of government. So it was the Ten Commandments was displayed alongside these other historical artifacts. So in that context, it didn't smack of promoting religion. It was part of a larger, very diverse display of symbols involving legal and political history. So anyway, it was upheld. Here's our most recent one. There you go. Gigantic cross that's on a public highway there. That's American Legion versus American Humanist Association. This cross was put up 100 years ago. And that length of time, that was pretty important to the U.S. Supreme Court, the length of time it has been there. And the reason it was placed there, that was important to the court as well. It was there to honor men who had died fighting in World War I. And so it wasn't there to express any sort of religious message. And so there was no religious purpose, no desire to promote religion. The purpose was to honor veterans. That plus the fact that it had been on display for 100 years was the reason why the U.S. Supreme Court allowed it to be there. But they also kind of mentioned something, and this isn't critical to their holding. You would call this dicta. But the justices wrote that they were concerned about setting some sort of precedent through which governments would decide, oh gosh, we've got to go and start taking down all of these monuments, all of these crosses and nativity scenes. We've got to go remove all these things that we've had on our grounds for forever, for decades. The U.S. Supreme Court didn't want that to start happening. They didn't want cities to go and start removing monuments all of a sudden because of this decision. So it's interesting that they were kind of look at the practical effect of it. And now we're going to move on to the free exercise clause. And So this is, whereas the establishment religion, the concern is over coercion or promoting religion. The free exercise clause involves suppression of religion, not wanting to suppress religious exercises and religious beliefs. So it's kind of the flip side. We have our very first case dealing with that free exercise clause was Reynolds versus United States. It was decided in 1879, and it provided our distinction between belief and conduct. That's what's so significant about this case, is because it notes that, okay, the courts, the government cannot restrict what you believe, but it can restrict what you do. So there's your distinction. Government can restrict what you do, but it can't restrict what you believe. It cannot restrict what you believe. So it's belief versus conduct. So this case particularly involved polygamy. And polygamy has been a crime in the United States of America for as long as the United States of America has existed. It was a crime in other countries, and it was just universally applied all over Western Europe. Polygamy has been a crime. But in the late 1800s, a new religion had formed called Mormonism. And the founder of that religious tradition believed that he had been told by an angel that men had a religious duty to marry many women. That so polygamy was a requirement of men who practiced Mormonism. And so as applied, that criminal law, as applied to Mormons, prevented them from carrying out this religious practice. The U.S. Supreme Court said, well, they aren't telling you what you can believe or not believe. They aren't saying the law isn't preventing you from believing polygamy is necessary, but they can stop you from practicing it. So they can not restrict what you believe, but they can restrict what you do. So polygamy is a crime. It remains a crime in the United States of America, in spite of the fact that, at least for a time, they don't do it anymore. This is not a practice of Mormons anymore at all. But for a time it was. Anyway, so that's where we start out with the free exercise clause, that distinction between belief and crime. In 1940, the court selects the free exercise religion as being fundamental to due process. So now states are subject to scrutiny for any law that is a restriction on the free exercise of religion. The earliest cases deal with the state laws that limited the activities of Jehovah's Witnesses. One of the tenets of their religious tradition is to proselytize. Young people are required, this is like a rite of passage, to go and knock on doors and try to convert people to their version of Christianity. So it's a requirement for them to solicit. So that's solicitation. And many states have anti-solicitation rules, or rules that require you to get a permit and pay a fee in order to go door to door trying to sell anything. And so as applied to Jehovah's Witnesses, it seemed to be, or arguably would have been, a restriction on their exercise of their religious belief. But the U.S. Supreme Court thus far has said no. These are laws of general application. It doesn't affect what Jehovah's Witnesses believe. It just means that they are going to be regulated like any other organization would be, or they'd be treated the way any other organization would be that goes door to door trying to teach something or sell something. The Amish tradition, they are not going door to door proselytizing, quite the contrary. They're a very private group, but they do like to remove their children from public schools once they reach a certain age. And that conflicted with many state laws that compel public education through high school. But the Supreme Court has protected the Amish. They will not allow states to force Amish children to continue attending school. So that's a distinction there between the two traditions. Oh, there's a picture from Wisconsin versus Yoder. That's the case that was in our book involving public education. Now you're going to get to sort of the key decisions are and the more contemporary decisions involving the free exercise clause. And these are kind of close to home. Sherbert versus Werner involved a lady who lived in Spartanburg, South Carolina, and worked for a textile mill there in the 60s. She was a member of the Seventh Day. Excuse me, that is my dog, if you heard that in the background. So the Seventh-day Adventist Church believes that Saturday is the day of rest, the Sabbath day when people are not allowed to work. So this nice lady would, for a time, wasn't required to work on Saturdays, but then her boss at the textile mill started requiring her to do it, and she refused, and so she got fired. And she went to apply for unemployment benefits, and the South Carolina Commission that regulates the payment of unemployment benefits denied her application because they said you were fired because you chose not to work. So you could have a job. You're choosing not to. It's your choice. So we are not going to pay you unemployment benefits. But she pointed out the fact that people aren't required to work on Sundays. And so if you refuse to work on a Sunday, you can get unemployment benefits. So that's discriminatory. You're discriminating against my particular faith tradition that places the Sabbath on Saturday instead of Sunday. And the U.S. Supreme Court agreed with her. And they said, you're right. That's discrimination against your church. That is a violation of the free exercise clause. And it gives us a test. Does the law pose a substantial burden on the exercise of religion? Well, yes, it did for this nice lady. She would be violating the principal tenet of her faith if she were to abide by this law. So, because it is a substantial burden, the government has to show a compelling government interest for it, and they have to show that their law is the least restrictive means of promoting that interest. And that is where the state of South Carolina lost. They were discriminating. Obviously, they could give exemptions for religious exercise. They did give exemptions for people who worshiped on Sunday, but just not people who worshiped on Saturday. So it's discrimination, and that's why they lost. But then about 27 years later, we get the case of Employment Division versus Smith. And this is set in Colorado, Denver, Colorado, and it involves a drug rehabilitation facility. And there were two would-be drug counselors. They had applied for a job to help provide counseling to help addicts manage their addiction. And one of the requirements of the law in Colorado and in really all states is that drug counselors should not use drugs. The use of drugs is a crime, and it does. And so there's like, a list of controlled substances. What is considered a drug that is prohibited in this, prosecuted as a crime in the state of Colorado or any state? Well, peyote is one such substance, one such controlled substance. It's considered a drug. And so the state of Colorado made it a crime to use peyote. And it had been a crime. It wasn't new. It was just part of their laws. But these two men who were drug treatment counselors were Native American. And as many of you probably know, Native Americans use peyote in their religious exercises. And so when they were denied unemployment benefits because they got fired for using peyote, they brought this challenge, you know, and they were trying to apply the Sherbert test and say that this was interference, a substantial burden on the exercise of their Native American religion, and therefore they should be receiving benefits. Well, now we have the U.S. Supreme Court, and they side in favor of the state of Colorado. We're dealing with a 5-4 majority. It's kind of a close call, but the majority said this particular law is a crime. It's criminal law. It's a law of general application. Nobody is allowed to use drugs. It's a crime. So here, the law that's being applied to these gentlemen is a law that applies to everyone. It is a criminal law. And so where a law of general application is applied to everybody, where that is the case, even if it incidentally interferes with some people's religious exercise, doesn't mean that the law is invalid. States can have generally applicable laws, and they will be upheld in spite of the fact that they incidentally interfere with religion. And the court had to deal with the Sherbert decision. It didn't overrule it outright. Instead, it just noted some differences between the Smith case and the Sherbert case. So like in the Sherbert case, we weren't dealing with a law of general application. We weren't dealing with anything. I mean, the nice lady did not commit a crime. She was just denied unemployment benefits because she didn't want to work on a Saturday. Here in the Smith case, we're talking about a crime that had been on the books for forever and was commonly applied to everyone. So they kind of distinguished the Sherbert case and said that's kind of a different situation. So they did not overrule. But there was a good bit of controversy that was triggered by the Smith case. Politicians that sort of catered to religious conservatives, those who were in Congress got really busy going on the news and criticizing the U.S. Supreme Court for the Smith decision, and they wrote a law called the Religious Freedom Restoration Act. And it was an effort to legislatively reverse the Smith decision. The law would apply. It was a federal law written by Congress that was going to require states to show that their laws meet the Sherbert test anytime it interferes with the religious exercises of their citizens. And so that was written and enacted, signed by the president. It became the law of the land. And it quickly wound up in front of the U.S. Supreme Court, who invalidated it in part because there is no power of Congress to require a state government to pass any sort of test. That was far beyond the scope of their authority. So the original Religious Freedom Restoration Act was invalidated by the U.S. Supreme Court pretty quickly. But it was only invalidated in part. So it still applied to federal law. Federal laws have to abide by the act. They must justify their laws by the Sherbert test when they interfere with the free exercise of religion. And that is a rule that has been applied in a recent case called Burwell versus Hobby Lobby, involving the Affordable Care Act. So we know that the Supreme Court is sticking to it. The Sherbert test applies to federal legislation that interferes with religious freedom. At the state level, depends on the state, whether they're going to use the Sherbert decision or use the Smith decision. Another effort to try to provide greater protection for religious freedom was provided in the Religious Land Use and Institutionalized Persons Act. That is a law that would require that stricter Sherbert test for prison systems where their rules interfere with, wait, I may have that wrong, land use rules. well, no, I think it's both. Anyway, so here is a federal law that, Congress used or Congress enacted on the authority of the Commerce Clause. So they didn't have the same problems they had with the Religious Freedom Restoration Act. And the Supreme Court's interpreting it, applying it, allowing it. So the Sherbert standard's going to apply there. The current U.S. Supreme Court, as you probably are aware, are kind of trending towards that accommodation theory and greater protections for religious freedom. We saw a lot of that in the context of the COVID pandemic and some of the rules on building capacity and masks and mandates, those types of things. The U.S. Supreme Court is kind of leaning towards upholding the authority of religious organizations to exercise their beliefs and their practices free of government interference. That's kind of the trend in the Supreme Court right now, is to be on the side of religious freedom, accommodation theory. And that's the end of this module 11.